Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. At this noon calendar, we're going to hear the argument of the State of New York versus Trump. When you request your time, please understand that we have the record, we have your briefs, all of the briefs, and we're familiar with the facts of the case, so ask for the time that you need to make your most important argument. I'm going to ask now for the appellant to rise and tell me the amount of time that you would like for argument.
Good afternoon, Your Honor. Mr. Robert for the appellants. Should I make the ProHoc application before the time?
You can do either way.
The court previously granted my colleague John Sauer ProHoc admission for the brief, and this morning or this afternoon at this point, we'd like to ask the court's permission for him to argue.
Your request motion is granted.
Thank you, Your Honor.
The time?
Time, Your Honor, we'd ask for 15 minutes, 10 minutes in opening and 5 minutes in rebuttal, if that's
Okay, 10 and 5.
Brian Isaac, I represent the non-party appellate attorneys. I know you usually only have 15. Could I just get 3 and 2 on this? Reduce my time to 3 and 2, if that's okay.
Thank you very much. Won't argue with that. 3 and 2, 10 and 5, yes? So we have a limit of 15 minutes. If you want to, do you want to split that so that you can have rebuttal time?
As the appellate, I mean, we'll just take a full 15 minutes. I guess I wasn't quite sure how to divide it for the non-party.
Okay. All right. And you represent the state, right? So you.
Maybe one way to do it would be 15 for the main appeal and 2 for the other.
I would think that you should.
15 total, but it looks fine.
So you don't want any rebuttal on either one?
I'm happy to take rebuttal, Your Honor.
So why don't you do 15 and 2? I'm sorry, 13 and 2. Okay. If you would, yes.
Thank you, Your Honor, and may it please the court, John Sauer on behalf of the appellants. This case involves a clear-cut violation of the statute of limitations and the law of the case doctrine. Last year in Trump 1 at 217 AD 3rd, page 611, this court held that no liability could be assigned for transactions that were completed prior to February of 2016 or 2014. For
Mr. Sauer, that's premised on the fact that the statements of financial conditions cannot give rise on their own to a new violation of 6312, right?
That is correct. That's what
Then why didn't we say that in the earlier decision on the motion to dismiss when we were reviewing the motion to dismiss?
I think that's what the phrase, the continuing wrong doctrine does not apply to delay or extend limitations period means, because that is the continuing wrong doctrine. To say that like a 2017 or 2018 statement, is a new discrete wrong that's distinct from the original transaction that closed way back in 2012, that just is the continuing wrong doctrine.
You don't think it applies to Ivanka Trump's arguments on that appeal or to the Attorney General's now discarded theory that there was somehow a large amorphous fraud that somehow told the statute of limitations all the way back to 2011? Isn't that statement applicable to either of those two arguments made on the motion to dismiss appeal?
Your Honor, if I understand the question, the dismissal of Ms. Trump strongly supports our interpretation of the prior opinion because, of course, the allegations with her in the complaint are virtually identical to the allegations against the other individual appellants. So if you look at the complaint, you see virtually identical claims and theories as to those two. And once this court held she's not covered by the tolling agreement, she was completely dismissed from the case. The same should apply to anyone who's not covered by the tolling agreement here. And I would emphasize further, though, that there's really two errors here. Because even if the continuing wrong doctrine did apply, it still doesn't allow the trial court to do what it did, which is to go way back in time to 2011 and 2012 and assign liability and major consequences, huge financial consequences, based on an analysis that never looked at a 2017 or 2015 statement, said what liability flows from just that statement that comes much later in the course of conduct.
And loans which closed long ago.
Exactly right, Your Honor. And again, this court addressed this squarely in the Henry decision, which is cited in Trump 1, the CW Capital decision, which is cited in Trump 1. What Henry says is, even if you apply the doctrine, it only applies to allow liability for statements within the limitations period. But that's not what the trial court did here. That's not what the Attorney General's office contended. They said, oh, we're going to apply the continuing wrong doctrine. That contradicts Trump 1, so that was the first error. But then the second error is, once we've done that, we're going to pretend there's no statute of limitations at all. And we're going to go all the way back in time and assign crippling financial liability for transactions that concluded again in 2011 and 2012. So there's a direct contradiction, a direct disregard of the prior, this court's prior opinion. It becomes really clear, I think, when you look at, for example, there's a citation of the Yin-Shing Lung decision by the trial court. And the trial court says this shows this is a continuous series of wrongs, each of which gives rise to its own liability, when there was an opinion from this court 3 months earlier saying the continuing wrong doctrine does not apply. That makes it very clear.
But again, shouldn't we have said, or wouldn't we have said, these statements of financial condition that fall within the limitations period don't give rise to a 6312 claim? Shouldn't we have just said that? Would have saved everyone a lot of time.
I think that's clearly what the continuing wrong doctrine means if you apply it. And again, the dismissal of Ms. Trump strongly supports that. But in any event, Your Honor, even if the court doesn't agree with that, there's still a massive violation of the continuing of the statute of limitations, because again, under Henry and versus Bank of America and under the CW Capital decision, the most the trial court could have done is looked at the 2017 statements and said, what liability can I assess to that? Can I oppose to that? And that is not at all what happened in the trial court. There was just a complete disregard of statute of limitations and an analysis that again and again goes all the way back to 2012.
Even if we agree with you on the statute of limitations point, that would not result in the complaint in its entirety being dismissed. There would still be several transactions that would be not time barred or timely. So what is your response to, or what is your strongest argument as to for dismissal of those claims, those exited non-time barred claims?
Right, there would be 2 of the 10 that were charged in the complaint that we've identified that would only apply to those covered by the tolling agreement. Like Ms. Trump, if you're not covered by the tolling agreement, it's all gone, essentially. But in answer to your Honor's question, we argue that there was a complete failure of proof on the critical element of capacity or tendency to deceive, which is an element required of any 6312.
Well, if I can stop you there, are you talking about a failure of proof at trial?
Absolutely, Your Honor, as well as in summary judgment. So we raised this.
Okay, but cause of action number 1, which is the fraud-based claim under 6312, liability on that was not tried, right? That was determined at summary judgment.
That is correct, Your Honor.
Okay,
And
so
we
I
challenge it as to both, yes.
I don't believe we can look at the trial record to answer any questions about the sufficiency of cause of action number 1 based on fraud. Don't we have to confine our review to the summary judgment motion record?
Well, to the extent that the trial court, in the final decision, was repeatedly referring to reinforce its prior holding in summary judgment, yes. Now, our position, of course, is that the failure of proof is even more defined, even more clear when you look at the summary judgment record. For example, just a couple citations to put this in context. Summary judgment record, page 13965 of the record, is a Deutsche Bank witness, uncontradicted, saying if his net worth had been as low as $1 billion, for example, he would have gotten exactly the same deal. It would have been exactly the same transaction. That's uncontradicted. It's reinforced by the trial testimony.
But could the trial court have credited Mr. Hayes' statement? He's also a Deutsche Bank employee, correct? And he said that if the facts were, if the SFCs were incorrect, then they didn't properly assess the risk on these loans. Mr. Hayes said that. You would say that in your brief, I believe.
He made a much more generic, if you look at that particular citation. He made a much more generic content that we want to make sure we're being, compensated for our risk. What is not disputed is the testimony that if the net worth had been as low as $1 billion, and again, this is the testimony of Williams, if the net worth had been as low as $1 billion, the deal would have been exactly the same. And so it's astonishing if you look at, for example, page 1882 of the record, which is their schematic that they cite 9 times in their brief, they concede that President Trump's net worth ranged between, on their view, $3 billion and $4.7 billion throughout this entire period, which is miles above.
If you're talking about summary judgment, isn't it basic that you don't make credibility determinations on the motion?
Absolutely correct, Your Honor, and we have a repeated violation of that, as we point out in our briefing. For example, there's kind of astonishing credibility determinations to disregard unrebutted in the summary judgment record expert testimony. So if you look at 17.916, the summary judgment affidavits of Bartoff, where he explains how all these representations, virtually everything they challenge, is consistent with generally applicable accounting standards. They're GAAP compliant statements. That's unrebutted in the summary judgment record. It goes beyond merely being disputed and you couldn't decide it by a credibility determination. There's really nothing to the contrary. And again, these errors are all reinforced at trial, so we are challenging both of those. And if you look particularly at Professor Bartoff's testimony, you have this clear explanation that all the things that they say are misleading are things that are specifically approved in ASC 274.
Creating an issue of fact, correct?
Exactly right, Your Honor. That's exactly right, Your Honor. That's at the very least, that's a disputed issue of fact. And it isn't just Professor Bartoff. There's a whole series. There's Professor Flemons. There's a whole series of experts. When you get to, yes, Your Honor.
Well, you finished that, but then I have a question for you about the scope of the statute.
Go right ahead, Your Honor.
Okay, yeah. No, so just looking at the language of the statute, it says that it's enacted to promote the honesty and integrity in commercial marketplace in New York by stopping fraud and illegal business. So to accomplish this, the statute authorizes the Attorney General that whenever a person shall engage in repeated fraudulent, I know that you're challenging that, or illegal acts, that they can bring such an action. So why isn't the language of the statute here referring to the repeated and fraudulent illegal acts or persistent fraud or legality? Why doesn't that define the scope of the statute? Why do we need to go to harm or threat of harm?
Yes, Your Honor. So the standard is that, as this court held, for example, in General Electric, is there has to be a capacity or tendency to deceive or atmosphere conducive to fraud. And what we've pointed out is that you have a situation where there were no victims, no complaints, no evidence of causation, materiality, or reliance. There were sophisticated counterparties who, the understanding of the relevant marketplace, as this court said in the Nordbank decision, understood that they would be doing their due diligence. They did do their own due diligence. The uncontradicted testimony in the summary judgment record is everything we did was independent. We didn't rely on the numbers. That's the Williams testimony in the summary judgment record. All that is evidence, for example, the Domino's Pizza decision that we've cited powerfully makes this point, where all of that is lacking. All that is powerful evidence that there was no capacity or tendency to deceive, which ties into our point that every single one of these transactions would have looked exactly the same.
I'm sorry, counsel. What about deterrence? In other words, the AG would have the argument that maybe these deals went down fine as far as all the parties were concerned in these deals, but in the future, some deal might not go down well, and someone would be harmed by that. And so we need to deter parties from putting in, fallacious statements of financial whatever. Go ahead.
May I respond? I see
Yes.
my red light. Just to answer that question, the deterrence interest goes entirely opposite direction, where we have a situation where the Supreme Court disregarded unrebutted expert testimony that these are GAAP compliant. These are consistent with accounting standards, which don't require perfection.
No, but the Attorney General points out that whether or not they're consistent with GAAP principles, it's the factual inaccuracies that are important. So in other words, you might be following GAAP principles, but if your data is terrible, then you're creating a fallacious statement.
With respect to that, completely it disregards or at least misinterprets our expert testimony, which look at what they say is factual data that's misinterpreted. For example, appraisals. Essentially, the Supreme Court said if you got an appraisal in your file, you got to rely on that. You can't rely on your own independent judgment. They say that's a factual inaccuracy. GAAP says the opposite. At least that's the unrebutted testimony in the summary judgment record. And I would direct the court to page 17916, the beginning of Professor Bartoff's summary of opinions on that.
I want to turn your attention to a different subject because your red light is on. I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Mones, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million, and it generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions. Do you have anything to say about those restrictions taking it down in value to such an extent?
Those are, I'd say, two things in response to that. First, the Shubin affidavit directly addresses that. That was improperly kind of disregarded.
He says there are no restrictions on it. He says there aren't, Shubin says there are no restrictions.
He says you have to interpret, he says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say he couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx in footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting, clear and basically statements that comply with gap, and you're held, well, we have another standard, I know it when I see it, that's good, that's bad. People can't do business in real estate. So,
Thank you.
thank you, Your Honor.
Oh, I'm sorry, there's another question.
Oh.
Sir, are you asking us to draw any bright line rules as to the contour of the AG's authority under 6312, or are you asking us to scrutinize the evidence that was adduced either at summary judgment with respect to claim number 1 and then at trial with respect to 2 through 7?
The latter, Your Honor. So our argument is on the unique facts of this case, you cannot come to the conclusion that the plain language of the statute was violated. And we argue, obviously, that they raises constitutional questions as well under Grasso and under the excessive fines clause and so forth. We make all those interpretive arguments. But the fundamental point is, if you look at these unique facts on this case, the statute just doesn't cover it. And if it does, it has no limitation.
It's your position that under the facts of this case, 6312 didn't support the taking the action that was taken.
That's exactly right, Your Honor. Thank you, Your Honor.
Good afternoon, Your Honors. Brian Isaac, as you know, I represent the non-party appellant attorneys. My argument is not as sexy as the other arguments, but I think it's a hugely important argument to me as an appellate litigator. I think that the New York State judicial system is the best in the world. I don't think it's better arithmetically, I think it's better geometrically. And I think most of the credit goes to you, but some of it goes to us also. You can't do your job in an exemplary fashion unless we do our job competently. And every single lawyer who practices in New York knows it's not what you get at the trial level, it's what you keep in the appellate division. It is an absolutely horrible idea, in my judgment, to sanction attorneys for making motions for summary judgment in cases where they have to do it to preserve the issue, not only here, Your Honors.
You don't want to take a chance on the appellate court saying, oh, they didn't preserve the issue.
Judge, it's not only here. This is a Trump case. Like him, don't like him, it doesn't matter. This case is a case that definitionally could go to the Court of Appeals. Look at 522B41, look at Cialina against Erie Preserve, look at the number of amicus briefs that you had. I couldn't even read them. You have to preserve these issues. And there's one fact that I want to bring to your attention. I know you know it, but we probably should have brought it out in the brief more. You have interest of justice jurisdiction. You can, if you want, decide unpreserved issues. You almost never do it if you don't believe me. Just run my name. Just put Brian J. Isaac, in quotes, within 8, put preserved, unpreserved, not preserved. See how good I've done. I'm not 0 for 5. I'm not 0 for 10. I'm 0 for 3 decades on that. But this court can do it. The Court of Appeals can't. They do not have any interest of justice jurisdiction. They are not allowed to decide mixed questions of law and fact. They can't decide damage issues. They can't decide that a case is against the credible weight of the evidence. How can a competent attorney, and these people are competent attorneys, risk a $440 million malpractice claim by not raising an argument that's a tenable argument? And I'm not going to go over my time because I don't, but I wanted to say something to you. The Attorney General and the trial judge excoriated the lawyers for making a motion for summary judgment on disgorgement at the summary judgment level. One of the cases they rely on is People against Ernst & Young, which you know. Can I read to you what you said? This isn't Brian Isaac. It's not Michael Ross who wrote the brief for me. This is the Appellate Division, First Department. I'm reading it verbatim. Quote, therefore, while the Attorney General does not allege direct injury to the public or consumers as a result of defendants' alleged collusion with Lehman Brothers in committing fraud, the equitable remedy of disgorgement is available in this action. Here's the key point. And it was premature to categorically preclude it at the pleading stage. That's verbatim. That is exactly what these lawyers did. And to be sanctioned for it is just wrong and threatens the integrity of what I think is the greatest juridical system we've seen. You shouldn't allow it.
Thank you. Counsel. So you have 10 minutes on this first. You have 10 minutes on this.
Well, I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that
Okay.
I think that maybe simplifies things. May it please the court, Judith Vale for the New York Attorney General's Office. All of the defendants repeatedly
Ms.
violated.
Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
Well, several responses.
And I want to add to his question, and little to no impact on the public marketplace.
Well, maybe I'll take that first, Your Honor, and work backwards. There was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here, but it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record. And you have to remember something. As the net worth as the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower. And then you do the stress test, and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated. That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr. Hay,
collateral.
doesn't Mr. Hay testify that there were 14 factors and this was the least important factor?
Well, certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors that are being
point.
considered. For materiality, it's whether it's important to the overall total mix of information, and this was absolutely critical to the overall mix of information, not only because they were looking specifically at what the net worth was in order to decide the terms of the loan, in order to figure out whether they would take on this risk, but also the financial statements were coming in each year, and they were important, critical to the loans each year, because Deutsche Bank was reassessing the risk every single year, and it was using—
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But
And-
it wasn't wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing?
And that concern is here as well, because when you have hidden risks getting injected into the
I
market,
don't know how you
that
can-
hurts the market and honest participants in the market. And the legislature also decided, contrary to what defendants think, that making sure that business in New York stays honest is the way to attract and keep
So
business
to
in
that
New York.
point, the Executive Law 6312, I just want to read a section of it. Well, not exactly, but was enacted to promote and protect honesty and integrity. It's the same question I asked the other side. In commercial marketplaces in New York, by stopping fraudulent and illegal businesses. To accomplish this purpose, the statute authorizes the Attorney General to bring civil enforcement proceedings on behalf of the people whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transacting of business. I don't read harm or threat of harm in that, but the other side is saying that that is to be read into the statute. Are there any cases where the language harm or threat to harm limits the scope of the Attorney General?
No, Your Honor, not as to liability, and not in cases like this where what the Attorney General is seeking is injunctive relief and disgorgement. Greenberg for the New York Court of Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here. And remember to think about the illegality claims as well, because it's not just fraud.
That's
Could
the
you just
very
let her
po-
finish the question? Just
So for the
answer,
illegality
please.
claims, you look to the underlying penal law provisions. And for something like issuing false financial statements, there's no requirement for reliance. There's intent and there's materiality, which was proved at trial. But if someone issues a false financial statement to their counterparty, the counterparty gets it and is not fooled, picks up the phone and calls the enforcement authorities, the crime has still been committed, even though the counterparty didn't rely on it at all.
So you're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money, and that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace, you've got a scheme to get unsophisticated consumers to take out home loans, you got a collapse of Lehman Brothers. You don't have anything like that here.
Well, first of all, Your Honor, the statute doesn't require that whatsoever for liability. And the statute is written broadly because the legislature wants the Attorney General to go in and stop fraud and illegality.
Counsel,
whether
an
it-
example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes,
was-
and the
it didn't affect the
investors-
public, I mean,
Sorry, go ahead.
at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do? And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, that where people don't claim harm. So what is the limiting principle?
Well, I'll say two things, Your Honor. Well, first of all, the limiting principle are what's in the law. So the illegality claims require intent. They require materiality.
Let's talk
most
about the
of them.
but talk about the standalone.
Just for the 6312 fraud. Well, this court has defined that rather broadly, but there are still limits. It is not falsity in the wind, first of all. It is not falsity that you whisper to someone on the couch. It has to be related and relevant to the business at hand, and it does have to have a capacity or tendency to deceive. It has to have a capacity or tendency to deceive. And I will stress, Your Honor, that this does have harm to the public and to the markets. And I think what Your Honor is saying is that in some of the other cases, the ripple effects happen to happen. It went so far that the ripple effects from fraud went on to hurt the market. But what the legislature wanted was 6312, just like for the Martin Act. And the Court of
those
Appeals
cases
talks
where
about
you-
this in assured
aren't those
guarantee.
cases
To be
where you
prophylactic, is that
investigated
what
the
you're about to
fraud?
say, counsel?
Yes, look at the assured guarantee case from the Court of Appeals. It talks about how a big point of these statutes, not the only point, but a big point is for the Attorney General to go in quickly to stop the fraud and illegality before it gets to the point that counterparties are harmed or it has those kinds of ripple effects in the market. I do want to, though, push back on the idea that Deutsche Bank never complained and wasn't harmed at all. Deutsche Bank did complain. When they first found out about the alleged misstatements and omissions, they raised serious concerns with defendants, said that misstatements in the financial statements would be an event of default. They asked for more information, and when they didn't get more information, they exited the entire relationship with the Trumps. That shows that they cared about the financial statements being truthful and accurate.
What
and
year
that
was
they
that
were,
in? What year was that in?
it was right when they first heard about the allegations, so I believe it was 2020, Your Honor, although I'd have to check the precise year on that. And Mazars as well, when Mazars found out about the alleged misstatements and omissions, they also sent a letter saying these financial statements should not be relied upon anymore. So it is not true that the counterparties didn't care or never complained, even though that's not required for 6312.
Also, I'm
Go
sorry,
ahead.
I'm moving off topic, so if you have a question on this, go ahead.
Maybe a better topic than mine. Back to Justice Moulton's point about line drawing, because I do think that is very important in this case. You know the history of this statute. It's passed under then AG Javits, and then was really amplified by AG Lefkowitz over the years. And when I went back and read the bill jackets, the common thread was always we need greater power. The AG needs greater powers as the people's lawyer to protect consumers, civil rights, and the environment. And so again, with that sort of historical backdrop to this law, how do we draw a line or at least put up some guardrails to know when the AG is operating well within her admittedly broad sphere of 6312, and when she is going into an area that wasn't intended for her jurisdiction?
Sure, Your Honor. Well, I will say, although there was certainly concern about consumers, especially at the outset of 6312, in some of the legislative history, there were multiple bills being passed, and some of them were more specifically consumer protection statutes, which I think explains some of the focus. And the legislature wrote this statute. It doesn't say consumers in it. It wasn't focused. I mean, of course, we want to protect consumers. I'm not.
And
not
it
saying
does
otherwise,
it does start off with the words to protect honesty and integrity in the commercial marketplace. So
Yes, Your Honor. And it also is it says quite broadly, whenever any person engages in fraud or illegality, whether that is meant to include businesses large or small, because this kind of deceptive risk does cause problems for the honest business people who don't do it this way and don't get the ill-gotten gains. And it does inject risks into the market. I mean, Your Honor, there was probably a time when most of us didn't know what a repo 105 was, which is what brought down Lehman, or what a RMBS was. And maybe, in an ideal world, the Attorney General or somebody else would have gone in and stopped that fraud and illegality when it was still just among the sophisticated counterparties and before it had the enormous harms and ripple effects that it ended up having.
Let me just ask you, you mentioned about the ripple effect, going on. If the threat of harm, or whatever the ripple effect, is so remote, does the conduct fall still? I mean, how remote does it have to be? It's the same question with regard to this line drawing, in order for the AG to follow through.
I mean, I think the remoteness
Or
problem
until
is,
it's
yeah,
outside of the scope of the statute as
sure.
intended.
I mean, I think, at least for 6312 fraud standing alone, I think the limit does come in through the capacity or tendency to deceive requirement. I don't think that the legislature wanted to have this kind of like evaluation about the precise harm out of a specific transaction. I mean, that's why harm is not, I mean, harm is an issue that might be for restitution, but that's not an issue here. But there is a limit, and it comes from the tendency or capacity to deceive standard that this court has put on that does incorporate a materiality-like standard. I think when we say materiality is not required, we're talking about the reasonable investor, that materiality is not required. It's just which objective person you're looking to. There's still an objective standard. So there are...
That's a good point. And so which objective person are we looking to here, given that it is the nature of the transaction that it is? I don't want to belabor the background.
I mean, it doesn't... this court has said that the standard for 6312 fraud standing alone is the objectively reasonable, ordinary, and even unthinking person. But in this case, the court could use the higher standard, and it would be fine. Because
I notice you say the ordinary standard on page 55 of your brief. You say, these deceptive strategies had a capacity, a tendency to deceive because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings, and you cite to General Electric. Isn't the test here whether they were likely to mislead Deutsche Bank or Ladder Capital or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and entities in business.
Well, if the court wants to use the standard of an objectively reasonable counterparty, sophisticated counterparty, fine. They had a capacity or tendency to deceive that sophisticated party as well, because these misstatements and omissions were about objective facts that were extremely important and that any reasonable counterparty would want to know. Any sophisticated, reasonable counterparty would want to know that the defendants were valuing an apartment based on 20,000 square feet more than it really was, based on pretending that rent regulations on certain apartments didn't exist, based on pretending that the Mar-a-Lago restrictions didn't exist. Your Honor asked about that. The trial court was very clear that it was not coming up with a magical valuation for itself. The problem with the Mar-a-Lago valuation is similar to what happened with the rent-regulated apartments. The restrictions in the deed are there. They are an objective fact. They are very restrictive. And even defendant's own expert at summary judgment, this is at 16502 of the record, agreed that the restrictions would decrease the value of Mar-a-Lago, but defendants valued it as if those restrictions didn't exist at all.
Counsel, I want to ask my question because your red light is on.
Absolutely, Your Honor.
Madam PJ, is that okay?
Yes.
For the disgorgement calculations, wouldn't it have been more appropriate to calculate them by calculating the difference in valuation of the property versus the valuation provided to the banks to get the loans?
No, Your Honor. The disgorgement calculation, what we needed was the reasonable approximation. What is the reasonable approximation of what defendants' fraud gained them? And defendants' theory is that the guarantee and the financial statements each year were worth nothing. But the point of the guarantee and the financial statements each year was to get the extremely favorable interest rates. And we were not speculating about the difference in interest rates. We had the counteroffer that Deutsche Bank, their own lenders, provided them for a loan without the guarantee and the financial statements. If I could touch very briefly on the statute of limitations, Your Honor.
I think we have it. Did you have another question?
I have a question that's
And I'll
similar
give
to
you
Judge
time for a
Rosado's,
second.
actually, which is the immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud. This went on, and illegality. It went on for 7 years during the statute of limitations period. Another reason is because the guarantee and the financial statements each year worked to get enormously favorable interest rate savings to the defendants. It was a difference of approximately 4 to 8 percentage points, obviously varied by year. That is an enormous benefit that they got from the misconduct, and it is not an excuse to say, well, our fraud was really successful, so we should get some of the money.
Was there double counting in the damages assessed for the old post office and the Ferry Point?
No, there was
deals?
not. There was not double counting, Your Honor. Two points on this. First of all, the interest rate savings and the sale profits are separate pots of money. The defendants got the interest rate savings off the top. There's no suggestion that they invested that savings into the OPO. They were using the loan, and so they got the interest rate off the top. That was the savings that they got. Each year, within the statute of limitations, they were getting a savings by doing the fraud over and over again and the illegality. And then the sale profits are separate. And the sale profits, it's not the proceeds. The proceeds of the loan of the sale were around $370 million. The trial court took out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around 126 million in profits, was his profit. That was his profit or more. I'd happy to talk about the statute of limitations quickly, although I see that my red light is on, so.
Well, I'll give you more time for.
Sure, Your Honor. On the
give
statute of
you-
limitations.
How much? I'll give you 3 minutes.
Thank you, Your Honor. On the statute of limitations, each use of a misleading statement in business and each issuance of a false financial statement is a violation of the statute. And it is helpful to look at the illegality claims. Every time someone issues a false financial statement, that is a crime, and it is no excuse under the statute of limitations to say, oh, although I issued a false statement in 2017, I should somehow, for statute of limitations purposes, be free and clear because I also issued a different false financial statement in 2011.
Is there any tension between your position and our prior decision that said we have to look to the accrual as of the date the transactions were completed?
No, Your Honor. I think the best reading of that language is that the transactions completed, the transaction is referring to the conduct that the statute is referring to, which is the fraud or illegality. So each time you issue a false financial statement, for example, that is a transaction.
I don't think it's referring to the loan.
No, Your Honor. If the court had wanted to refer to the loan completing or the loan initiating, it would have said that. And Ivanka was much differently situated. The problem, for what this court said about Ivanka Trump was that she was not sufficiently involved within the statute of limitations for her with the certification, preparation, review, or use of the statements. That was why she was released from the case. Whereas the defendants that remain, each personally were involved in the preparation, issuance, and use of the statements in business. And it would really be a distortion of 6312 and this court's precedent in cases like Allen. A similar thing was happening in Allen, where the original relationship between the counterparties started before the statute of limitations, but then new fraudulent or illegal acts were happening within the statute of limitations. And what the trial court said there, and what this court affirmed, was the new conduct that happened within the statute of limitations is timely and actionable, but the things that happen outside of the statute of limitations are not. And I do want to emphasize that neither the trial court nor the Attorney General sought liability based on the fraud or illegality that happened in 2011 or 2012. That is not true. After this court's decision, the Attorney General was not pursuing its claims for the interest rate differential for 2011 or 2012 or 2013. We were pursuing that before, and because of this court's decision, we stopped. And the trial court appropriately separated it and said the claims that are based on fraud or illegality that happened before 2014 are out. And the ones that happened in the statute of limitations period are in.
Do you want to respond to?
Well, I can touch very briefly on the sanctions, Your Honor. I think for the sanctions, I'll say two things. And one is it was not just one frivolous argument. It was multiple frivolous arguments happening. including both at summary judgment, raising the argument that disgorgement is not allowed under 6312 as a categorical matter. That is foreclosed by controlling New York Court of Appeals precedent in Greenberg. And counsel misquoted Greenberg in making that argument to make it seem as if Greenberg had not said what it said. And it was that combined with raising purely legal arguments about standing capacity to sue, raising those arguments again for the third time after the trial court had warned them and said at the motion to dismiss stage, these arguments are frivolous, but I'm not going to sanction you now, I'm warning you. And I understand the need and the feeling to preserve, the need to preserve arguments for appeal. As an appellate attorney, I understand that. But what counsel did here was not write a sentence or two and say, for the purposes of preservation, we are adding this to our brief. They wrote the whole argument again, relying on all the same cases and all the same legal arguments without explaining what, as a factual matter, was different, and that was unnecessary and frivolous.
Thank you.
Thank you.
Mr. Sauer?
Thank you, Your Honor. Just pivoting to that last point, last year, the Attorney General's office was here on the continuing wrong doctrine, making the exact same arguments. This court rejected them and Trump won, and we're hearing the same arguments again, citing some of the same case law. That was sanctionable for our attorneys in the lower court, but here we are. Now, I want to point the court to two citations in the summary judgment record that I think frame a lot of the questions that my colleague was asked. At 13865, there's unrebutted testimony in the summary judgment record that at least creates a disputed material fact that President Trump would have got the same deal from Deutsche Bank if his net worth had been as low as $1 billion. In their calculation, it was never below $3 billion, so it's triple the threshold. And the clear testimony is the interest rates would have been the same. He would have been they held up a chart that would have been on the same pricing chart. So this notion that there were these 8 basis points at issue is just not supportable. Secondly, at 20,042 to 44 of the record and in other places, the Deutsche Bank witness said, we independently assess all these valuations. We are not relying on the numbers that the client is giving us, but we do our own independent assessment. That is our due diligence. That's the understanding of the relevant marketplace.
I'm sorry, sir, but
Nordbank?
So we're talking now about cause of action number one, the fraud under 6312.
Yes, and the causation argument as to disgorgement. Yes,
okay.
Yeah.
So we know under, point taken, as to the liability on cause of action number one, we know fraud under 6312 has a much broader meaning than common law fraud. And so there it's, as your friend pointed out, the standard is the capacity or tendency to deceive. Did those statements have the capacity to deceive?
Absolutely not, Your Honor, for at least 3 reasons. First of all, they're gap compliant. They're not misrepresentations. All the key things they point to is this was wrong and this was wrong. The unrebutted testimony, certainly in the summary judgment record starting at 17,916, is this is what you do in a financial statement. You are allowed to do this. You are allowed to predict, for example, that you'll get your rent restrictions lifted or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartov said is that appraisal could be sitting on your desk and you don't have to rely on it. And there's actually really powerful evidence in this case to show why that's true. Because if you look at 40 Wall Street, they said, in 2011 and 2012, the appraisals of 40 Wall Street were at 200 to 220 million, and you said 527 million. But they overlooked that a couple of years later, Cushman revised its appraisal and said it's worth 540 million, virtually matching what we had said and they say is misleading. So it's kind of these astonishing issues. It's very similar to the valuation of Mar-a-Lago as $18 million based on a tax assessment. It's preposterous. It's a preposterous position that these factual things. So that's my first answer to that. But secondly, more importantly, we have sophisticated counterparties, as a lot of the questions pointed out. They're getting clear disclaimers. The disclaimers say what everybody already knows you do in this industry. You do your own due diligence. So how is there a capacity or tendency to deceive when you have these very clear disclaimers saying considerable judgment is required here. These values don't reflect what might be realized upon a sale and so forth.
But what about the Attorney General's point that may be true in this case, but we are trying to create a fair and honest marketplace, which will inure to the benefit of the public in the long run?
Yeah, and I would say 2 things in response to that. First, all the questions about line drawing. If this case falls on the other side of the line, there is no line. I mean, you heard, I think, for 15 minutes, respectfully, my colleagues struggle to articulate any clear principle that would put any transaction outside the reach of the statute on the Attorney General's very broad and sweeping view. So our position is narrow, which is that on the facts of this case, all these things I've referred to, no reliance, no materiality, Deutsche Bank saying we would have given them the exact same deal, and we have clear disclaimers. Surely this is not within the statute, and if this is, there's nothing that falls outside of the statute, and that is a sweeping and unsettling thing. The second point I'd make about that is—
And I'm sorry, just to tie a ribbon around that, do you mean based on the facts as they were adduced on the respective records, the summary judgment motion as to cause of action 1, the trial record as to 2 through 7? Not that the AG didn't have an interest, at least at the outset, in investigating and maybe commencing the proceeding.
we're not disputing that in this
They
appeal.
certainly have that
You're
interest.
saying once you got all the facts before the court, which we
And
didn't have last
that may have been, I wasn't on that case, but that may have been the point of our prior decision, which Mr. Isaac brought up, about this being at the pleading stage. Yes, so it was enough at the pleading stage, but at the end, doesn't mean this is what should happen.
That's exactly right, Your Honor. Here we have all the facts before the court.
But the pleadings in this case, I'm sorry, counsel, but the pleading in this case is like a novel. It goes on at length, 327 pages or something like that. And basically, those were the facts that Justice Ngoran found were proved at trial. So aren't we bound by our prior decision? I asked this question in another way before.
Very significant variations. I just want to flag one. I see my red light is on. The pleading, the complaint, cites GAP like 50 times. They said these statements are bad because they violate GAP. But you go to the summary judgment record, they have nothing. They don't put anything on GAP. The trial court never cites GAP. Our experts say these are GAP compliant. That's unrebutted. So there's this totally, the record looks totally different once all the facts are in. And I know my time has expired, so I thank the court for its time.
Thank you.
Your Honor, I'm actually going to go under my time. I just have one observation, and I don't know, maybe I'm wrong about this, but this argument, if it doesn't show why not making a summary judgment motion was appropriate, I don't know what is. There was absolutely nothing wrong with what the attorneys did. My adversary said that she's relying on the Ernst & Young case. I read to you what you said. That's exactly what you did. One more point, and I'll sit down. Keep relying on Greenberg. This is what the Greenberg court said, Greenberg 2. Initially, we note that defendants may not raise issues on appeal that were not preserved on the record for our review. So even if they're right about what this court said and they're not right, it wouldn't matter anyway because lawyers have to preserve issues for all courts that may consider it. They have to look at things not temporally at the time, but what could happen afterward. And given that, and I'm not, this isn't Brian Isaac or it's not Michael Ross, I'm reading to you from the court. They did what they were supposed to do. They did what they had to do. To sanction them is just wrong.
Thank you.
Thank you.